What is up? Welcome back to the docket presented by Defense Stars. I'm your host, Bob Mata. And I didn't anticipate coming on today, but per usual, the case that never sleeps. Got another filing. And I think I did a live on this Friday, and we went through a lot of the outstanding stuff. And this thing came down today. It's not a huge one. It's interesting though. It's just another move in this bizarre game of chess that's being played. Um, you know, and I'm clearly biased for the defense in this particular case, just because of everything that's been going on. And I'm a defense bar guy, so and I'm not going to apologize for that. And I'm just not a YouTuber that likes true crime and tries to solve cases. I was a lawyer for 23 years and tried cases, so I have a reason that I am defense sided. That being said, obviously, when things go to trial, if a guy's a scumbag and they prove it, I'm all for it. I don't have to try the cases anymore, so I'm allowed to be on the sidelines, rooting for bad guys to go down, provided, of course, they have the evidence to get them. So before we jump in, some incredibly sad news. If y'all been following Audrey Hemming or Cunningham, they recovered her remains today out of the Trinity River and down there in Texas. Of course, that's incredibly sad. I just don't understand people. I don't get it. I don't understand it. I don't know. I can't, I don't function that way. I would never think about hurting a child. So I can't, it's really, really difficult for me to wrap my mind around it. It really is. It's just one of those things that I'll never understand it. And, this dude that they've got in, looks the part. I hate to be that guy who judges a book by its cover. But that guy is looking like the guy. It's for certain. And the cops and the state are pretty convinced that they have the evidence that they're going to be able to put him down. And down there, it's an eye for an eye. Down there they will execute you. Illinois is no death penalty state. Down there they'll execute you, and I'm assuming that's what'll happen to him, provided they can prove the case. So, what else is going on? Oh, Ruby Franke and Jody Hildebrand both got sentenced. Wide range there, and that was for that bizarre child abuse case with the woman who was using her kids as a means to make a lot of money on YouTube. And all of her kids were beholden to her and had to, basically perform on demand, which must have been fun for the kids. I imagine they must have really loved that. I couldn't have imagined trying to get my 17-year-old Cameron, going into her room. I keep wanting to start this little kind of YouTube short series called The Unwakeable that stars Cameron. It's just videos of me trying to go in and wake her up for school. You guys would love it. I have a feeling it would go viral because she's not a pleasant person in the morning trying to get out of bed. All right. So hello to everybody out there. Welcome. Hello to my mods that are kind enough to be here. I don't know who's here. I know I saw Dizzy is back. Welcome back. I know you've been under the weather. I know Sandy's in here. I know Meg's in here. CH Kasha. I see a lot of my mods in here. And of course, Stevie is backstage with me, helping me. Somebody asked who Stevie was the other day. Stevie and Mandy. They're my ride or dies. They handle all my stuff. They handle my graphics, the thumbnails. They handle all the. He is. It's exactly right. Anything that you're seeing on my screen, that's them. and they're amazing. And they frankly, when we're starting the morning drop, which is coming, I'm still waiting on one piece of the set to get in, and that's going to be cool. That's going to be a 50s themed daily morning news show, but just court stuff, court and true crime, in and out. It's not going to be this long 2-hour stuff, which I know you guys like. I'm still going to do these two, but we're going to do that every morning. We're going to let you all know what happened the day before and in the trials, and it'll be Allie and I, and we'll have surprises and fun stuff going on in there as well. Try to keep it a little light because our subject matter is dark, always dark. And I think it's imperative that we have a little bit of levity in there in order to keep it, certainly not sitting there laughing and having a great time, but a chuckle occasionally is absolutely called for. So I'm looking forward to that. I hope that you guys will dig that too. I think it'll be a good watch. And I think that will give you a little bit more in depth than they can do on your court TV type morning shows. And I love Julie Grant. I'm on with her quite a bit. But they're just limited. They have very short segments, and I don't have those rules. So if there's something that we feel like we need to dig in a bit more, we can do that. And I don't have to go to a commercial every 4 minutes. So that's nice. All right. Okay. So let's get to it. So the most recent filing is a response. Okay. Let me pull it up here. And as you may or may not know, Stevie, can you make me bigger again? I don't know why, dude. Just like make that a normal, like, oh, see how money that guy is? Ask and ye shall receive. All right. So this is the defense's response to the state's motion to compel discovery. I went over that on Friday, y'all. So I'm not going to go over it again. It was pretty basic. It was McClellan saying, "Look, we've got this hearing coming up, and I want stuff. I want them to turn stuff over to me. I should be able to know what's going on, and it's different. It's a different hearing, because this hearing isn't relating to the defendant, which is what Michael was talking about when I went through his particular response, where he was asking for a summary denial of his contempt motion. And basically in that, if this is a criminal contempt hearing, then McClellan screwed up. He's got to bring it under another case number, because remember, Rick Allen is the defendant, not Baldwin and Rosie. So if he's going to proceed under an indirect criminal contempt proceeding, he's got to file it under a new case number. It's got to be a different case. It's a completely separate collateral issue to the underlying case. It has nothing to do with it, other than the fact that they happen to be representing the guy, and the guy's discovery was part of what they're complaining about. Other than that, it's all a mess. It really is. When I talk about, and I've been doing this a long time, I've just never, and I've been in sticky cases. I've never seen one like this. It's unbelievable. And it really is. It's every day. Like there's almost never a day where there's either a filing or an order by the judge, sometimes both. All right, so let's go through it. All right, so comes now the accused, Richard Allen, by and through counsel Andrew Baldwin and Brad Rosie, and files his response to the state's motion to compel discovery. Paragraph 1, on January 27th, 2024, the state of Indiana filed a pleading entitled State's Motion to Compel Discovery, requesting until February 26th, 2024 for a response. On February 8th of 2024, the court ordered defendant, and this is in quotes, defendant to respond to the state's motion to compel discovery on or before February 21st, 2024, or provide the discovery requested. Paragraph 3, the defense attorneys on this, so you guys are with me so far, pretty straightforward. It's everybody was like, oh, well, the state filed a motion, then Gull gave the state a date right away. Of course, we've got multiple motions still pending from the defense, and we haven't heard anything. It's just weird. Like, I don't want to get on my rant about her again, but it's weird. It looks weird. Like, why would she be giving? So yes, I wasn't going to do it. I almost started doing it. All right. So the defense attorneys on this matter reinstated on January 18th, 2024. Paragraph 4, 12 days later, January 30th, 2024, the defense received the bulk of the discovery in the form of multiple hard drives. Now, when I first read this, initially this morning, I'm like, what? I'm like, this dude had like a November 1st discovery deadline, and now he's dropping like truckloads of shit on the defense. I'm like, how does that work? And don't get me wrong. Don't get me wrong. There's discovery deadlines that are set in order to encourage the sides to get their discovery in reciprocal discovery situations, which means each side has a duty to provide discovery to the other. It's different what the state has to provide to the defense, but they do have reciprocal discovery. They especially, like in Illinois, we definitely have it, and I know they have it in Indiana as well. So I was like, what? Like, meaning that there can be late discovery. Like, because remember, I say it all the time. If you listen to my podcast, which all of you should, like seriously, if you're digging this in terms of YouTube, you're going to love the podcast. The podcast is next level. The Gacy thing and the Garcia thing, and people are just complaining about Garcia, but it's 50 episodes. What I should have done with Garcia is broken it up into 5 seasons or 6 seasons. That way people wouldn't be complaining. I mean, there's no other podcast on the planet that has a 50 episode season of one story. The complaining with that just kills me. I have to write the scripts. It's a lot of work. So, but yeah, check it out. It's good. So essentially what happens is after the defendant is arrested in a case, I talk about it all the time, that the investigation is not over. It's just beginning. And they will continue to investigate this up until the day of trial. Sometimes they'll be investigating while trial is still going on, trying to dig up witnesses, it doesn't stop. So, but it's all about giving the side, one or the other, the notice that they got discovery and giving them an opportunity to review it. And if it's somebody that they need to talk to, the court typically will give them the opportunity to talk to them. We've had discovery pop up the day before trial, the day of trial. We're sitting there objecting. The judge is like, well, why don't you go in the hallway and make a phone call? I'm like, so it just depends on the judge, but discovery can come in late. A discovery deadline just means get everything that you have ready now over to the other side. That doesn't mean that if discovery is discovered later in the process that they're foreclosed from being able to use it. It can create issues depending on what it is. If it's something that's of the nature of, very inculpatory and the state's going to want it, the likelihood is the judge is going to allow it in, no matter what the defense argues, as long as the defense has an opportunity to vet it, before trial starts. So, so when I saw this morning, I'm like, what? Like truckloads? I'm like reading, and when you'll see what I'm talking about when I keep reading. So 12 days later, January 30th, the defense received a bulk of the discovery in the form of multiple hard drives. In addition, between January 29th and January 31st, the defense received 6 separate e-discovery emails from the state, all of which contains volumes of audio, video reports, transcripts, and other docs. Paragraph 6, after reviewing just a portion of the evidence contained on the hard drives and the e-discovery drops, it became apparent to the defense that the discovery received includes evidence the defense believes it had never reviewed or had a chance to review. Perhaps between September 2023 and January 18th, 2024, the state of Indiana provided this evidence to counsel that replaced attorneys Rosie and Baldwin. So at that point, I forgot that they had to turn all their discovery over. So theoretically, and it's not like they went to the old dude scrumming in Labredo and said, "Hey, man, give us our discovery back," it all gets processed through the state again. So those guys, when these guys turned it in, they gave it to the state. The state then tendered it over to the new guys, and then when these guys got reinstated, same thing. They had to turn it over to the state, and then the state reissues it back to these guys. Now, what they're saying is that when they got it back, there's new stuff. It's either new stuff or stuff that they hadn't gotten to yet. They seem to be implying that it's new, is the way that I read it. Paragraph 7. The state and defense are also in ongoing communication, so it sounds like they're talking again, regarding evidence that may exist but has not yet been found by the defense. So, I mean, maybe that's a bright that's a bright spot, maybe. Maybe they're communicating again. You remember McClellan said that he wasn't going to be communicating with them via text or email, I think. Maybe he just said text. So I mean, they have to communicate. There's got to be some communication between defense and the state in prepping for a trial like this. Doesn't work any other way. Paragraph 8. Regardless, the defense is reviewing the discovery as quickly and as efficiently as possible, often late into the night, to determine what discovery exists on the hard drives that was already known to the defense on October 12th, 2023, versus new discovery that the defense does not believe it has ever viewed, and evidence that the defense believes exists it cannot locate in the discovery provided. Excuse me, all. So, discovery in a case like this, and as you can see, and they talk about it here, the volume of discovery is massive, including minimally 20 hard drives, as well as 6 separate e-discovery emails. And as of the date of filing, the defense has less than 3 weeks to review the discovery. Now, if you're sitting there saying, well, they already reviewed a bunch of it. Well, the problem, oh my God, that scared the shit out of me. Thanks, Stevie. Literally scared the shit out of me because in my headphones, it was really loud. So people are going to be laughing about that. Did I look like horrified? That scared the shit out of me. So essentially, when discovery is first tendered, and as we all know, and I believe that index was probably prepared by the defense, that was accidentally leaked to Brad. I forget what his name is. The guy, Westhouse or what? No, not Westerman. You guys know who I'm talking about. The other Brad, the Brad that Andy sent the email to with the index of the discovery. I believe that was prepared by the defense. And, because that's what happens when we get discovery. If we get voluminous discovery, you start going through it, item by item. And whether it be reports, whether it be audio, whether it be video, whether it be witness statements, affidavits, whatever the case may be. And then you start creating an index. So, what I'm reading here is it sounds like that they didn't get it back in the same form that they sent it back to the state when they were removed from the case. Meaning, essentially, they have to go through all of it again and start to get it all into a working fashion again. And it's incredibly time consuming, because the state will say, this is what we've tendered. Like, we typically get it what's called bait stamped, and bait stamping is where they stamp each page because, they're probably getting some paper documents as well. I have a feeling that a vast majority of it is on the hard drives and then in the discovery email. So they're probably not getting like actual paper as much as we used to get it. In most prosecutors' offices are trending towards doing everything electronically, which frankly is much easier. It really is. But it doesn't make the act of having to go through the discovery piece by piece any easier. I mean, you're still having to read, you're still having to watch and listen. And, depending on what kind of discovery is, and then you're cataloging it to see what you've got. And then you're comparing it to what the state says that they've tendered to you. And, and if you've got things that aren't working, like CDs or videos that just won't run, and it happens all the time. I mean, it's one thing for them to override, which my friend Brett over, the prosecutors was like, "Oh yeah, that happens." Spoliation of evidence happens all the time. Well, it does happen. I wouldn't say all the time, and typically, it's not spoliation of the type to where the actual like the actual piece of evidence, the originating piece of evidence has been overwritten to where we can't get a copy of it anymore. And look, if it's the state's evidence, I don't care. Right? Oh, that's a real shame that you recorded over the confession of the defendant. That sucks for you. And when it happens to be something that could be exculpatory, then I'm super mad. I mean, the bottom line is they need to really kind of maintain the discovery in a way that they'll be able to reproduce it if necessary. So spoliation does happen on occasion. I like the use of the term all the time. Was a gross overstatement. I mean, I've been practicing for 20 plus years trial work, and it was not an all the time thing. And anytime that it happened, it was an issue. We were sitting there screaming, yelling, and pounding our fists on the table and saying, this is unconstitutional. And what about our clients' rights? And, all that good stuff. So they've got this massive pile that they're trying to get through. And the first thing I start thinking about when I'm reading through this is the likelihood or unlikelihood that we're going to get a speedy trial on this thing. The more time that passes, the more evident to me it's becoming that we are not going to be getting a trial anytime soon. If you asked me to guess, like once it's off the speedy trial track, y'all, like it then just takes the normal route of most of these high profile type cases, which is 2 to 3 years. You know, Somebody asked me today on Twitter, they're like, do I think this thing's going to go? Or maybe it was I think it might have been my buddy Dan asking me he messaged me asking if I thought it was going to go in October. And I don't know. I mean, at this point, I would hope so, but I don't know. It depends. I don't know what the discovery is. It's one thing for them to be saying that they're ready, but like they haven't even gotten to the point where they're actually able to start preparing for trial because we're dealing with all this bullshit still. And people are like, oh, like this isn't the defense, y'all. Like I'm just telling, just look at who's filing the shit. Like this thing is not the defense trying to stall or delay. Once again, this is the state delaying. Just like removing defense counsel was the state and the judge delaying the trial, not the defense. I mean, you can make the argument, but for them allowing the leak on their watch, well, but for Gull not knowing the law and removing them improperly, we might be done with the trial at this point had it started January 8th. That's facts. And everything that's being filed now, I shouldn't say everything, but this most recent thing, I mean, we don't know because she just doesn't set anything the defense files for hearing. It just sits there like in a weird fugue state, like some kind of weird vampire, just like laying there. And she doesn't give it dates, but she gives the state dates immediately. So, because they've still got their Their pending motions, their motion to dismiss. Of course, no date still yet. It's a pretty big motion for her not to give a date on it. Like, I don't know. Is she just waiting? Is she gonna really try to remove these guys again? Because to me, like I said on Friday, all these issues are what they call race judicata. It's been decided in a court with jurisdiction over the matter. I mean, like, all of these things are all the same things. It's like he's beating a dead horse with this shit. Like, to like, for what end? To what end? He wants them to, like, be put in jail for a week, to delay trial a little more. Let's give them a week in jail where they can't work on the case as punishment. I don't know. It's frustrating. It really is. All right, so let's keep plowing through this thing because I want to get done with this by 7. There's that thing on the CW about the case. I think it's got a bunch of creators. So I can't wait to see how that's going to be. It's like people film for these things and then they're all excited to watch it. Like us when we did our Dateline. And then they make you look like total douchebags. It's how they do it. They take a lot of video and they cut it and put things out of context. And, I have a feeling it's going to be like an expose on how toxic the online world is with respect to this case, like these two warring factions. And, so I don't know, but it sounds like it's going to have some interesting stuff. It's got Ron Logan's ex-girlfriend, I think. She's going to be on there spilling some tea. So that'll be interesting. I know, like, I've never really talked about the Ron Logan stuff, but I'm not I'm not so sure. He seemed old. Seemed like a really old man to pull this thing off, in my opinion. And that's just all that is my opinion. I mean, obviously, it's unsettling that the girls were found on his property, but in terms of logic, he seems a tad old, a little bit long in the tooth to have done that, but who knows? Maybe he was spry, real spry old guy. All right, so paragraph 10, in terms of the state's request for the defense to provide a witness and exhibit list, the defense would seek an extension of time to file its preliminary witness and exhibit list until Monday, March 25th, 2024. This will hopefully provide the defense enough time to review the massive discovery to determine what witness it may call at trial, including expert witnesses and what exhibits it would expect to introduce. Now, the other thing that I was thinking when I was reading this, because when I was reading McClellan's motion to compel discovery, as far as witness lists, to be honest with you, when I read it and I believed that he was asking for discovery for the upcoming hearing on the 18th, not the trial that's set in October. Like, that was my impression. Like, McClellan wanted to know who they were going to be calling, what they were going to be saying, what exhibits they were going to be putting up. And, like that, and that actually hasn't changed. I think that particular motion was pertaining to the upcoming hearing, not the overall trial date. So this is a little cagey by the defense here, because they're pretending like, well, that's absurd. Like, this is his motion. We don't have to give him jack shit. So he must be talking about the trial. So, and they're writing it as such. They're writing it talking about, because obviously seeking an extension to March 25th puts them a full week past the hearing date. So, that they're saying, "All right, well, this guy, like this guy," because they had to have looked at it the same way I looked at it. Like McClellan was rooting around trying to find out what they're bringing, what kind of receipts they're bringing to the hearing on the 18th. And I don't think they have any obligation to give him anything for that hearing. It's his motion. I mean, if they're going to go in and defend it, they go in and defend it. I don't think they have any reciprocal discovery, especially because he didn't file it in the right place. Maybe if he had filed it as a criminal action, and if Kara's in here, maybe she can answer. She said she was going to hang in the chat, or if Shay's in here, or if Michael's in here, if any of you guys are in here and you can answer that question definitively for me in the chat, that would be glorious. But for me, it, it's their motion. I don't know that they would have to provide anything in terms of defending it. So, but again, we're in front of Gull. So she's going to, probably rule in favor of the state, whatever that may mean in this. She may deny this, which I don't know how she'll be able to deny it unless she's looking at it like this. She's like, oh, well, you're coming at, this with the approach that he was referring to trial. And that's what he wants discovery for. He wants the reciprocal discovery for trial, when in fact, he was talking about getting discovery for the upcoming hearing. I mean, and if that's what he was asking for, then maybe he should articulate it in a motion. You know what I mean? It helps. It helps to articulate when you're practicing law to what you're asking for specifically, not just broad sweeping generalized statements. So again, Nick can thank himself for that. If in fact, but we'll see how this shakes out. But that was just a thought that I was having. And I was going based on my gut when I was reading his motion to compel. I really thought he was referring to the upcoming hearing, that he wanted stuff for the hearing. And I think in my live, I made that pretty clear that that was how I felt about it. So paragraph 11, certainly the defense wants to accommodate the state's requests, especially as it relates to the state's need to react to any expert witnesses that the defense may present at trial. All right. So again, the defense is sticking to the trial thing. The defense believes that by March 25th, 2024, the defense should have a much better grasp of the discovery that it has received, and therefore a much better grasp of which fact witness and expert witnesses it expects to call and what exhibits it may introduce. 13. And just so you guys know, I mean, as defense attorneys, we have a duty to investigate the case as well. I mean, we have to investigate it on behalf of our client. We have to see what their theory is, and then we send out our PIs, and they start digging, and then we're trying to work on our theory of the case. Because remember, again, I say it all the time. Nick McClellan wasn't there when the girls lost their lives. Either was Liggett. Either was Holman. Either was Doug. None of those guys were there. No one was there other than the perpetrator or perpetrators and the girls. So all we have is a theory of the state that they've based on the evidence that they've been able to collect. And that's all it is. That's why, like I don't even listen to people when they're talking about their theories. They don't know shit. Like you're guessing on stuff until this goes to trial and everything gets vetted. And that includes the defense's shit. We don't know shit. I don't care what they're saying in pleadings. All we know is that they're going to have an alternate suspect theory. That's it. And we've got a general understanding of what it's going to be. Just like we have a general understanding of what the state's evidence is at this point based on their PCA. And that's all it is. People spend an awful lot of time making videos and having lives where they're trying the case. And if you'll notice, I've never done that because you can't. I mean, I guess maybe it's a fun exercise for them, but acting like they know shit when they don't know shit, it's not how it works. Thing it's got to go to trial, and hopefully it gets to trial, and that's where everything gets vetted. That's where we find out what's what. When I'm sitting here saying that I think that PCA leans innocent, it's what it leans to me, and I'm not basing that on anything other than the fact that I practiced law for 20 years and I read PCAs and I know weak evidence when I see it. That's what I'm basing it on. What are you guys basing it on? The guilty folks. Oh, that he put himself at the scene. Yeah, check, got that. He's made the confessions in jail. Check, I got that. He's got witnesses that all describe somebody that looked differently. Check, I got that. I mean, for those out there that are heavy duty in the guilt camp, you know, um, if you're right, I hope they have the evidence. That's all I'm going to say. Because if what they have now, if they get a truly unbiased jury, because all of us that follow this case assume that everybody's into it like we are. They're not. They're just not. You could just drive to Indianapolis. And I bet I would hazard to guess if you ask 10 people, just random people on the street, if they've heard of, the Delphi case or Abby and Libby's case, I'd say 7 out of 10 haven't. When we're in this world, we think that everything revolves around it. The outside world doesn't know. They don't care. It's not in their orbit, so the likelihood that they're able to, even to Allen County, I have very little doubt that they will be able to find 12 jurors that know little to nothing about this case. If this shit wasn't going on with Gull, like what that's going on, Allen County jurors wouldn't know anything about this case. Like the news in Allen County isn't reporting on it like they are around closer to Delphi. Around that area, are they reporting on it? Sure. But are they reporting on it constantly? No, they're not. And as crazy as this case is, and as much national attention as it's gotten, it's still not that much. If you think about it. If you're watching national news, like how long did it take Dateline to do a thing on the Idaho 4 thing? It's like we had Barb McDonald's down the hill podcasts, and there was a companion piece to that was done documentary style, and then we had the book, and a few other people have written books. But in terms of this being and it should be, I can't scream any louder than I am, in terms of getting eyes on this case, because procedurally, I've never seen anything like it, ever, ever. It's unbelievable to me. All right, let's keep rolling on this thing. All right. So again, the defense believes that by March 25th, the defense should have a much better grasp of the discovery it has received, and therefore a much better grasp of which fact witnesses and expert witnesses it expects to call and what exhibits it may introduce. They can't do that until they've gone through all the discovery. You can't possibly know, what kind of experts you're going to need until you dig through all the discovery and you find out where your issues are. I keep saying, because they wrote it in their memo, that they didn't find anything of issue in any of Allen's electronics. So theoretically, you can chalk that one off as somebody they don't need. They don't need a forensic electronics guy. Does that mean that they won't get one? No. What happens if they think that stuff was photoshopped? Everybody always assumes that the sound of guys down the hill is attached to that video. I don't know that. I mean, we all assume it just because they put them out around the same time. I mean, like that picture of Bridge guy is so blurry, it's so blown up. Like you can tell that that's blown up like massively. He must have been 40, 50. I don't know how many feet behind, and the audio, I'm sure they tried to enhance it some, I mean, they're certainly gonna hire experts to see, what they've done in terms of trying to enhance audio and video, and I'm talking about the state and the feds, whoever did it, and they're gonna be trying to get back to the original, see what that sounded like. But as I sit here today, I don't know definitively that sound comes from that video. I mean, it would seem to me wherever that sound was, if it was in that video, that it had to have been when the gun was taken out, because otherwise Abby and Libby be like, "Fuck you, dude," and run unless he's got the gun out so that he has control, So, and there's certainly no gun that's visible in the bid, like in the small 3 seconds or whatever we got out of the 43, So we just got to see it all. That's my whole point. It's like we're trying to, like, you got people out here trying to solve the case on bits and pieces, the breadcrumbs they've thrown out there. Can't do it. You can't do it. What you can do is look at that PCA and admit it sucks. Can do that. I mean, I don't know where y'all would be if McClellan wouldn't have puked out that, that he had confessed multiple times over a jail call. Like if you guys were sitting here waiting for trial and those confessions hadn't taken place and all you had was some guy who volunteered that he was at the bridge wearing the same shit that everybody in that area wears. I don't know. No real definitive timeline. I mean, that's the thing. We've got this floating timeline with Allen. Was he there from 12:30 to 1:30 or 12 to 1:30, or was he there from 1:30 to 4? Like, which is it? I see Sleuth Intuition always making these videos. I'm like, where are you getting this shit, dude? He's got little cars driving around, and I mean, that guy's really trying the case hard, man. I'd love to debate that guy. I remember one time he's like, "Oh yeah, anybody who knows what they're talking about, lawyers," and then he blocked me. So, what the deal is with that? And I don't know why it bugs me, but it does. Like it's just like that guy in particular with that move, just like I don't know, because I encourage people that disagree with me to come on. I'll debate as long as they're competent. I'm not going to get on there with the raving lunatic and debate. But if it's somebody who's got thoughts and, and could put together a strong argument as to guilt based on the limited, information that we have, I'm here for it. Let's go. I'll debate you, under the premise that we both understand that we don't know what all the evidence is and it hasn't been vetted at trial. It would merely be an exercise. But, I'd be just trying to hammer home the point that PCA sucks. There's a strong argument that it wasn't even enough for an arrest. I'm sorry, but that's factual, and if Allen's the guy, they better have more. That's all I'm trying to say. All right, let me finish this guy up. Yeah, because I'm already 15 minutes. Like when I start my ranting, I eat up time. All right. In terms of the state's request, oh wait, I think I've already read that one twice. So 11, certainly the defense wants to accommodate the state's request, especially as it relates to the state's need to react to any expert witnesses that the defense may present at trial. So that's very nice. See how nice they're playing? They want to accommodate the state. See? Sweet guys. Sweet guys. All right, 12. The defense believes that by March 25th, 2024, that the defense should have a much better grasp of the discovery it has received, and therefore a much better grasp of which fact witness and expert witness it expects to call and what exhibits it may introduce. To show evidence of good faith, the defense has already provided the state of Indiana with the names of certain expert witnesses and other witnesses the defense currently plans on calling at trial. This information was provided to the state of Indiana on or about February 14th of 2024. In its motion, the state of Indiana also requested the defense provide the state of Indiana in advance notice of exhibits concerning which defense which the defense intends to question the deponents. So this is where it is. So this is them in paragraph 14 basically acknowledging that they understand that I think that whole motion, not just portions of it, I think that the bulk of that motion was relating to this hearing. And then McClellan was trying to get a heads up in terms of what they're going to produce so he can be prepared. I mean, that's got to be a little bit scary for McClellan. You know, I mean, these guys aren't just going to sit there and get bitch slapped. Like, if he hasn't figured that out by now, I don't know what to tell him. Like these are not two chump clown attorneys. I love when people call them clowns. These guys have 50 years experience collectively. They know what they're doing. They're good lawyers. I'm telling you, you're going to see it at trial. That's where it's going to be really evident. The gap in terms of experience. And look, trial work is only learned through doing. You can't read how to try a case properly. You cannot read how to cross-examine properly and effectively. You have to do it. And you have to do it when it counts. This isn't moot court. This is the real deal. This is with all the chips on the table. This is the real McCoy. It's a much different experience. And the two guys that he's going up against have done it a lot. They've handled many, many murder cases to verdicts. They know what they're doing. You know, and he just keeps poking the bear. Like with this thing, like as soon as Mike Oscott's thing came out, she should have just said, you know what, I'm like, and just said, you know, I want to get this thing moving for the families. I'm just going to withdraw this because this is just wasting more time. The Supreme Court, it's already ruled on it. Like, my fault. I'm going to pull that thing back. And then you know what? We're moving forward. Instead, this thing has everything else stalled. We've got more motions being filed, more responses being filed. We've got this hearing, which frankly, I'm really looking forward to. I'll be sitting front row in that thing, taking amazing notes, because I'll tell you right now, I don't care who else is covering this thing. The only place to be after that hearing is on this YouTube channel. I promise you. There's no one in that courtroom that is going to be able to give you a better analysis of exactly what went on in that courtroom than me and Allie. And I've got like a busy weekend coming into that. Like, I'm going to be down in Marion working on this wrongful conviction case that I'm doing. So like, I'm having to fly from St. Louis Sunday night to Indianapolis in order to stage myself in Allen County to get in line in the morning to make sure I get in. So I do it for y'all because I love you. All right. Which is true. I do. All right. In its motion. Okay. I already read that one. So 15, the defense does not believe this request is legally sustainable, as no local or trial rule mandates that either side is required to turn over exhibits before depositions. So, excuse me, y'all. Still got the semblance of the cold thing. All right. So, because I talk so much in between, I want to read it again. 14 is, in its motion, the state of Indiana also requests that the defense provide the state of Indiana in advance notice of any exhibits concerning which the defense intends to question the deponents. So you guys all know what a deposition is, right? A deposition is where they have somebody out of court under oath court reporter, witness, defense attorneys, grilling, and the state will be there. McClelland will be there, or if law enforcement, whoever's dep it's going to be, they may have their own counsel. Maybe there's union counsel there. Somebody will be there representing them, and this is where McClelland may get pantsed in terms of this whole thing. I mean, like I said, I tweeted it. I don't know if I said it on Friday, but I guarantee you the main thing the defense is going to be digging into is how McClelland got his hands on Andy Baldwin's work product text messages between him and Westerman. That is their primary focus. And when that and Nick, he's got to be like, he's got massive scrutiny on him. Like, I'm not of the mindset that Nick's evil or any of that shit. Like, that's not my game. I know there's people out there. I think Nick's inexperienced. I think he's in over his head. I think he's got a massive amount of pressure, and I don't think he has enough help. That's what I think about Nick. Nick may be a phenomenal attorney, but he just got dumped like the world's biggest case, and it spun out of control. And this guy doesn't have like an entire office to like fall back on. He doesn't have the senior prosecutor who's been prosecuting cases for 40 years who he can go to and say, man, dude, what do I do here? Like, this shit's crazy. He's floating there. He's got Luttrell. That's it. He's in a tough spot. He really is. It's like people have to understand the practice of law is a tough business. It just is. It's not easy. It's like you guys are always watching end games, and I'm talking about the trial. There's a whole bunch of shit that goes on in between, and you're seeing it now. Like, typically when you're watching trials, because just now in the last couple of years have they started showing pretrial motions, which is where I'm always saying the war is fought, because that's what determines what evidence is coming in and what's staying out, and that's where the war is fought. What you're seeing is the end battle, where they've plucked all the evidence out that you're not going to see, because there's huge fights about what's going to be introduced or what's going to be admissible and what's not. And that all takes place now, pre-trial, and we haven't even gotten there on this. Like Gull is doing McClelland huge favors by not forcing him to go to hearing on this, because on any of these motions, because he's got to prepare for those. When she drafts those orders up, just denying it, that is a huge boon to McClelland. Because otherwise, we're a year into this, and I have not seen the man litigate anything. The only thing that I've ever seen him do any litigation in over a year is like, I mean, what are we, a year and 5-6 months? Like, the only thing I've seen him litigate is the safekeeping thing back in June. That's it. I haven't seen him litigate anything else. And for a guy who I can't Google what his trial experience is, like you can with Baldwin and Rosie, you have to wonder, can he try a case? I don't know. He might. I don't know. Like, honestly, I have no idea if he can try a case or not. I don't know. So there's that issue. Okay. And basically, so the defense is saying that they don't believe that this request is legally sustainable, is no local or trial rule mandates that either side is required to turn over exhibits before deps. Additionally, providing the deponent an opportunity to review certain exhibits before the deposition takes away the spontaneous responses of deponents that often reveal dishonest answers that are later useful at trial. When deponents have a chance to prepare for their answers by reviewing evidence ahead of time, the answers are no longer spontaneous, but are prepared, which is very, very true. The defense would object to the state and deponents from having a preview of any of the exhibits the defense plans on introducing at deposition as violative of trial strategy for both sides. And then wherefore the defense will request until March 25th to provide the state of Indiana with its witness and exhibit list. So there's that. So it's interesting. I anticipate that we'll be getting an order on this quickly. I don't think this is going to, like, Gull will fire this thing off. She'll either grant the date, but I'm telling you, it's not as clear cut in terms of what McClelland was asking for. If he's asking for, uh, whatever they're trying to put forward at the hearing, and it's like the judge can't call him ex parte, which means one side without the other side being there. Like she can't hit Nick up ex parte and be like, "Hey, Nick, like, are you talking about the hearing or are you talking about the trial, buddy?" Well, judge, yeah, I mean, that can't happen. So the judge just has to go by what's on the four corners of the document, and it's hard to tell. So I don't know. So yeah, I think in 3 minutes that bad boy is about to start on the CW. So I'm gonna let y'all bounce. And I might pop on after that thing, depending on whether it's good or if it sucks. So, but in the interim, I have portaled all of you to my boys, Publicly Buzz, Steve and Dan. Apparently, Steve found some interrogation that he says blew his mind and was the most insane thing that he's ever seen. I'm torn. Like, if I couldn't just watch it on replay, I'd be jumping over there. But I hope you all stick with those guys because I love them. They're my brothers. And I'm going to end this thing so I can get you over there timely for a change instead of a half an hour into their stream. And make sure y'all, my boy Jay is going to be jumping over with those fellas tomorrow night. And Jay has a huge stream tomorrow on his channel that I'm really looking forward to myself. Jay is going to be covering the Rust trials, Baldwin and the armor. I always forget what the armorer's name is. And the armorer's trial is first, and Jay has a couple of great guests, Alina Burrows, and I forget what the other lady's name is, but she sounds awesome. She's like in the industry. She's a film gal. Jay, throw in the name of who your other guest is tomorrow in the chat, bro. And because I want everybody to jump over there. I'll be hanging in the chat for sure for that one because I'm interested in digging into that trial with Jay, and I'm sure I'll sit in with him some. Just like I expect. Yeah, Alyssa. Does she just? You keep. It always sounds like you never say the A. You say it's Elisa, right? Elisa Statman. So she is like I met her for the first time yesterday in Jay's chat. She sounds amazing. She's got an awesome. There you go, director of Modern Family. How good can you get? Can't get any better than that. So all right, let's see. We got real quick. Oh, Nav the EO. Another what? I gotta find Nav the EO, who just gifted another 50 memberships. Aw, 50 family hugs. Thank you, man. That is so incredibly generous. That blows my mind every time you do that because that's not cheap. That is amazing. That is so generous, man. Jolene, thank you. It seems like it's been a minute since I've seen you, Jolene. Thank you for that $10 holla. Jen, and always give her $20 holla. There was a arrest a few days ago in Washington State. 2 men sacrificed a woman. I saw that. A man, a woman, a horse, and a dog to Odin. It's unbelievable. I guess it does happen. Apparently it happens. It's crazy. All right. Love y'all. See you later. Have fun over at Publicly Buzzed. See ya.